Attorneys representing former President Donald Trump argued to the U.S. Supreme Court Thursday that all presidents should have total immunity from criminal prosecution. We're joined now by one of those attorneys, Will Scharf. He's also a Republican candidate for Attorney General in Missouri, and he was in the highest court today. Good to see you, sir. Thank you for being here after a busy day.
Great to be with you.
It is the belief of your team that any president should have total immunity for official acts.
For official acts in office. And that's a very important distinction, as you know. Nobody here is arguing that presidents should have absolute immunity for their private conduct, but for official acts, acts that fall within the outer perimeter of a president's responsibilities in office, we believe that a president should have immunity, that without that immunity, the presidency itself would be crippled, and that no future American president would be able to effectively discharge his duties while suffering under the specter of potential criminal prosecution in the future.
Do you believe, listening to what you listened to, observing what you observed, that at least 5 justices agree with you?
I think the court was very interested at testing the bounds of immunity and was very skeptical of the arguments advanced by the special counsel's team that no immunity at all can exist, that a president should have absolutely no immunity for his official acts. So we were, I'd say, cautiously optimistic coming out of the court today that they see this issue as we do, that not recognizing immunity would do serious damage to the presidency.
What's striking about your argument, though, is that during the proceedings, your colleague conceded some of the allegations against the former president are not for official acts.
We've always conceded that there may be private conduct at stake, and that for private conduct, immunity would not extend. But again, some of the core allegations in this case involve things like asking the Department of Justice to investigate election fraud, considering an appointment to the position of acting attorney general. We consider those to be quintessentially presidential acts. And if immunity were not extended for acts like that, again, we believe that the presidency would be crippled.
But what about seeking clarity on election interference is an official presidential duty?
Well, the president has a take-care obligation under Article 2 of the Constitution to ensure that federal election law is enforced. I think it's an absolutely essential function of the presidency to ensure that we have a fair and unbiased election system. And so certainly investigating election fraud or considering leadership at the Department of Justice that would be more aggressive in investigating election fraud, we believe would fall within the ambit of the outer perimeter test set forth by the Supreme Court in Nixon v. Fitzgerald, the seminal case on civil immunity in the presidential context.
Okay, but so some of what he's alleged, your team argued or conceded, was private conduct, correct?
That's correct, but it was interesting. The lawyer for the special counsel's team, Michael Dreeben, effectively conceded that the indictment, as it's currently laid out, intermixes private conduct and official conduct to the extent that certainly at the very least, if any official immunity and any presidential immunity is recognized here by the court, we think a remand for further proceedings to sort of tease the bounds of that immunity would be absolutely necessary.
So then how do you argue that in lower court? How do you argue over the immunity issue at that point?
Well, the D.C. Circuit actually issued pretty good guidance in the Blazing Aim opinion last year, which was a presidential civil immunity case. They set out a test that looks at the function and official indicia of various acts, and that's currently an issue being litigated in D.C. courts. We think that provides a perfect model for the court here.
You are a member of the Trump legal team in terms of the immunity issue specifically, right?
I'm on President Trump's appellate team. We've worked on a lot of issues for him.
Do you foresee the Arizona election interference case ending up in your lap at some point?
I don't know. I mean, that's obviously the indictment was just returned yesterday. I would say that I think it's very interesting that once again we have an elected Democrat pushing a highly political prosecution at the height of election season. I think that's just wrong. I think when you look at all of these cases against President Trump, they smack of election interference and political motivations. As a former federal prosecutor, I was trained that prosecutions are never supposed to be political. They're never even supposed to appear political. I think we see the exact opposite playing out in courtrooms across America.
See, that's when you say that, the Democrat looking into election interference, wouldn't it have been a Republican president and a Republican Justice Department looking into election interference when he was still president? Isn't it all political? All of this is partisan at this point.
I fundamentally disagree that our courts and that the rule of law should be applied through the lens of partisan politics. I think that's banana republic stuff. And I think that's unfortunately the road that President Biden and his allies have set us down over the last couple of years. I think it would be really important for the future of the republic for the court to issue firm guidance on the issue of presidential immunity. And I'm hopeful that as we continue litigating all of these cases, we're able to vindicate the rule of law in a non-political way so that, frankly, the American republic will last.
All right. Will Scharf, running for Attorney General in a competitive Republican primary, we should point out, but today a co-counsel for the former president of the Supreme Court. Thank you for spending part of the day here.
Thanks for having me.
All righty. Take care.